Good morning. Welcome to the Appeals Court. I am William Meade. With me today are Justices Wolohojian and Singh. We'll be the panel on the cases today. We have read everything. My best advice is to get right to the point in your case. With that, I'll call our first case is 21P 1164, Ralph versus the Town of Dedham. Mr. Burke.
Yes, Your Honor. Good morning. May it please the Court. My name is Tim Burke. I'm here representing the appellant, William Ralph. This is a very straightforward case, and I believe in some respects the sole issue is whether or not the trial court obviously erred by not including the instruction that we had requested regarding temporal proximity. This was a whistleblower case. The facts, obviously, you know the facts. But what's important about this case is it's unique in the sense that we preserved the very issue that we believe we had the right to present to the jury. And that jury had the right, we believe, to know that the timing in terms of my client's employment, his protected activity, which was his objections to the Siemens project, which occurred on June 4th, 2015, in the temporal proximity of his termination, which was less than 2 weeks later. That was an important element that should have been identified to the jury and given as a basis for demonstrating that there was retaliatory animus. If you
so
look
in this case, there's no dispute that the issue is preserved.
Right.
Correct? Okay.
I think they conceded that, Your Honor. Yes.
Right. So we get right to the issue. Didn't the judge give model instructions?
If you look at just the model instructions, and if that's all that is required for a judge to do is to just comply with what the model instructions are, you're never going to have a case that's going to be reviewed de novo for whether or not it actually gave the jury sufficient information. And if it wasn't just that the model instructions were given, but if you look at what the retaliation was, the retaliation doesn't have anything about the timing of it. And this doesn't mean that in every single whistleblower case, you need to have an instruction on temporal proximity. The Christo case that you decided approximately 2 years ago was my case. And in that case, there was no request for a temporal proximity instruction because the protected activity happened 11 months before the termination. But here, it was so pointed, it was so close in time to his protected activity. And if you look at the jury verdict, the special verdict slip, clearly they accepted the fact that he had engaged in protected activity. So that's on question one. They found that. You go to question two. And on question two, the question is, did we prove that there was the requisite retaliation, that it was a product of retaliation for his protected activity? The answer is no, but the answer is lacking in the sense that the information that they needed to make the determination, they were never given. It's just the straight what the burden of proof was with retaliation. And
isn't that sort of a simple logical inference that if one thing follows another, that you can make that connection? Do you really need a jury instruction on that particular point?
Absolutely. And if you think about if you were all Superior Court judges and making a determination and motion for a summary judgment on a whistleblower case, you're doing the same thing. You have that knowledge because you know that if there's temporal proximity, that's a basis for the case to be submitted to the jury. Likewise, the information should have been imparted to them. They don't have the same amount of information that was necessary. They know we have to prove retaliation, but they don't know that as an element of the law in whistleblower cases, that the timing of that is an important ingredient. And when you say that they should know that or it's just automatic, what the court's reason was for denying my request, and if you stand back and you look at it, it wasn't that it was improper. If it was the motion, the language was questionable. The issue that the judge found was that the inference was too strong. But that's the very purpose of the instruction.
No, he didn't actually say that the inference was too strong. What the judge said was that giving the instruction in the way that you requested it was too strong.
Whatever the actual language was, the basis for it was not that there was anything inappropriate with the language.
No one's arguing that it's an inappropriate inference, that the jury were not allowed to draw an inference if they thought it was reasonable from the timing, that they could draw an inference regarding motivation or causation. I don't think anyone's arguing that they couldn't draw that inference if they decided to draw that inference. One of the things that I'm puzzled by is it didn't seem to me that in the closing, plaintiff's counsel really tried to argue the point. Do you think that was argued in the closing? Because I didn't really see that.
Well, obviously, I think there could have been more said in the closing had that instruction been given.
Well, no, why does the closing depend on the instruction?
Because it's an element, as if the instruction had been given. It's a component of demonstrating.
You could have made the argument, someone could have made the argument, regardless of the instruction.
Well,
there was no limitation on the closing.
It's clear that instructions are different from closing arguments. Closing arguments, as the judge says, is simply not evidence in any case. So whatever argument that was being made that this was that was retaliatory animus, it doesn't have the force of law that the instruction would have given. And the instruction that would have been given was an accurate statement of the law. And it was something that was relevant to the facts of that case.
Counsel, when you say it was an accurate statement of the law, perhaps the judge, in saying something to the effect of that it was too strong of an inference, perhaps the judge was indicating that the language of the instruction was not balanced, in the sense that an inference may be drawn, but alone it's not sufficient.
Well, Your Honor, again, any inference is a permissible as opposed to a mandatory or necessary inference. I mean, that's the purpose of demonstrating that there is a permissible inference. But if the jury isn't given that information, they don't have the ability to, when you say retaliation, one of the components in any whistleblower case is the timing between the actual protected activity and how soon thereafter a successfully performing employee is terminated. And there was no question that we introduced evidence, it's at 0309 in the transcript, there's no question that Bill Ralph was a successfully performing employee. He had no discipline, he had been here since 2010. And during that time period, he had repeatedly done and said things that brought into question the conduct of town officials. And when you're making the decision, and again, going back to the closing argument, the judge has, if there was some question about how the actual instruction was phrased, that doesn't in and of itself justify not giving an instruction that was based on temporal proximity.
But I don't also see why the absence of the instruction I'm really hung up on the fact that this argument was not made to the jury during the closing. They didn't argue temporal proximity in the closing. And they defended the case on a slightly different ground, which is that the purported the RIF, was not actually a RIF, but an excuse for terminating, sort of a false RIF.
Well, Your Honor, again, when you say I'm the one who did the closing argument. But when you say that it wasn't argued,
I don't see it. I'm asking you to point it to me if it was argued.
If you find that it wasn't argued, I know there was reference made to retaliation.
Right, but you didn't argue.
It's not argued.
Jurors, you can infer from the timing of my client's complaints to the city about, I think it was the Siemens project, and this supposed reduction in force, you can infer that this was actually retaliation for the complaint. I didn't see that.
Okay.
And if that's not a theory of the defense, then why should the judge instruct on it?
Well, Your Honor, because the judge recognized that there was sufficient evidence for that to be presented. And if you say that it was
Okay,
because
if it was, then why wasn't it argued
But if you
to the
say-
jury?
because the instruction that gave the jurors guidelines as to how you determine retaliatory animus wasn't provided. It is then becomes just my opinion as to how you can infer that. It's spoken in a vacuum without the guiding information that is given through the actual requested in jury instruction. And if that's not presented, it just becomes an argument that has nothing more than what a lawyer is making without the benefit of the support of law. It's not evidence in the case, but the judge's instructions do provide, they are the rule of law. It has a much greater impact and an ability to be argued if it's presented in a jury instruction. And that wasn't given here, and it wasn't given under legitimate circumstances. If you look at what the presentation that was given by the request for jury instructions from the town was able to get the judge to provide an instruction that he was an employee at will. And the town had every right to terminate him for no cause or any cause whatsoever. And if you think about the balancing in those circumstances, the jury has that information, and they find that he has protected speech, but that the retaliation isn't connected. The connective tissue comes from the instruction that we requested that be given. And the judge doesn't have an argument with the actual language that he could have ameliorated the language.
He has instructions that the retaliation has to be because of I think it was the second element, right? That it needs to be retaliation because of the speech.
There's no question, but like I said,
You just said they had no instruction on the connective tissue between the protected action and the termination. But they did receive an instruction.
All they received was retaliation, the instruction that had to be proven. And what you're looking for is information. How do you prove retaliation? And you prove retaliation, as you said, this court said in Ortiz, it said in the Ritchie case, one of the ways that the plaintiff can prove retaliation in a whistleblower case is by the means of either differential treatment or by the evidence of temporal proximity. And that's why it was so important to have that included. And it wasn't included. And that, in my opinion, based upon the unique factual circumstances here, was the linchpin between demonstrating the close proximity between his speech. It's clear that that he was speaking in a protected activity. And 2 weeks later, he's terminated. There was no disciplinary action. There's no other means for the jury to determine.
It looks like the jury rejected the contention that he was terminated, as opposed to this being a reduction in force. If we look at the verdicts as a whole, that's what it appears to me. And so if that's correct, doesn't that sort of undermine your position here?
One day you have a job and the next day you don't, and there's no basis for your termination. You're not being disciplined.
Well, sure. That's what I'm saying, but the jury it doesn't look as though the jury thought he was terminated, as opposed to that his position was eliminated and he was offered another position.
Well,
and if they accepted that, which it appears that they did, then how do we find any prejudice, even if we were to determine that there was some error or in the instruction?
Because I don't believe the jury instruction issue is dependent upon whether or not it's constituted a termination, or whether it's constituted a reduction in force, or elimination. You're talking about an adverse employment action that's taken, and that encompasses a broad spectrum and not just simply reductions in force. His working conditions changed on June 14th without question. And again, you go back to what the jury had is in terms of the knowledge that's given to them to help solve this puzzle. And it's a straightforward lack of information because it was a requested specific jury instruction on an important element in that case.
Counsel, our review of the judge's determination not to give that instruction, is it an abuse of discretion standard?
I mean, I think if you look at on Westlaw, you plug in, jury instructions, the vast majority of those cases are because they never preserved the question, or because there's some dispute about whether or not the language was appropriate. But here, it was a very pointed situation. And when you say abuse of discretion or harmless error, the real gravamen here is that the court didn't say, what the court concluded was that it was too strong an inference. Even assuming that argument for the moment, that it was too strong a direct inference, he could have still made changes in it or balanced it out and saying it's a permissible, you may infer, you're not required to. But it's the tool. It's the information that's given to them, that wasn't given to the jury, that you as judges do every day in making those assessments in the summary judgment case.
Okay, thank you, Mr. Burt. That's your notice.
Thank you very much.
Good morning. May it please the court. Gareth Notice for the appellee, town of DEDHAM. I think in order for the judge to give this instruction, and I think the standard was abuse of discretion. He had wide discretion to decide, based upon the evidence that was presented to the jury, what instructions he could give and how we could craft them and what sort of weight he could give to those instructions, and whether or not they might be prejudicial to one party or the other, or put too much emphasis on one piece of the case. So what would be the sources for the judge, the trial judge, to make this instruction? It would be the statute itself and the elements, the prima facie elements of the statute. Could be the model jury instructions that the judge, in my view, really tailored very closely to in his instructions.
I'll tell you what's bothering me here is that the judge gives no instruction at all on inferences, at all. And in fact, instructs the jury, you must decide the case based only on the evidence presented at trial. You may not decide this case based on anything else, and then says, what is evidence? As I told you earlier, you must decide this case based only on the evidence presented at trial. The evidence consists of testimony of witnesses, as you recall it, and the things that were marked as exhibits. You will have the exhibits with you in the jury room, things that were marked only for identification or not exhibits, and you will not be able to consider them. And so the jury is given no instruction at all. I mean, I may have missed it, in which case please point it out to me, about circumstantial evidence, inferences, forget a specific instruction on inferences from temporal proximity, but they've been told nothing about that they are able to draw inferences from the direct evidence. So doesn't that need to be considered in evaluating not only whether it was an error to give the instruction asked for here, but whether it was prejudicial?
First of all, I don't think that that's an issue before the court, whether or not the sort of preliminary instructions that the judge gave about
This is the
evidence.
final instructions. These are, what I'm reading you is in the final instructions.
I understand, Your Honor, but there was a great bit of discussion during the charge conference and in the instructions itself given to the jury about causation and what
Where?
causation is. And
Can you point to me the pages that you're relying on for that?
I can't, Your Honor, but I could certainly submit a supplemental brief if I went back and dug through to look at exactly where the judge instructed the jury on that issue.
I don't think it was extensive. That's the part that he gave an instruction it said causation. He gave no instruction about inferences.
My recollection, Your Honor, is that he followed, like he did for the whistleblower statute, the model Superior Court instructions.
There are
on
model
weighing the
instructions on
evidence.
inferences as well.
Well, they were not contained in the Superior Court instructions that he gave to the jury, Your Honor. And I don't think that, I think as Justice Singh pointed out, and I agree, it certainly could have been argued to the jury that the temporal proximity between this Siemens event and the termination was so close that you should infer that was the substantial and motivating reason for the decision to create this new position for Mr. Ralph. And it wasn't argued, and that was part of what I argued in the charge conference was.
Mr. Notice, I thought you argued part of the harmless error was that Judge Halal told Mr. Burke that he wasn't going to give the instruction and to argue it. And he said he covered it in his argument, so I'm confused. Did he argue it or did he not argue it?
I don't believe he argued it strongly enough.
How does
Your
that
Honor.
account for the harmless error analysis in your brief then? Did I misread your brief?
No, Your Honor, I think the issue is that there was no discretion that was abused by the judge. He had the ability to take a look at all of the evidence that was presented. And by the way, the issue of whether Mr. Ralph was a satisfactorily performing employee was in great dispute during the evidence.
The appellant had the opportunity to fully explain the significance of temporal proximity and to instruct the jury, which is an odd verb, on the significance thereof. The fact that he was ineffective in his attempt to do so does not mean that he was prejudiced. That's quite different from saying now that he didn't argue it at all.
I don't think he argued it forcefully enough, Your Honor. There certainly was a discussion during the argument about the Siemens project and perhaps giving that more weight than some of the other protected activity that dated back many, many years.
Let's assume he doesn't argue it or that he does argue it. In the end, if the jury's been instructed that they can only consider testimony and documentary evidence, and they're told you can base your decision only on those two things, then the fact that the plaintiff argues inferences, the jury's not told that they can draw inferences.
I don't think the jury was instructed that they could solely base their decision
I
on.
read what the jury, I'm reading from pages, in the record appendix, 987 to 988. It's not a matter of opinion. I just read what the judge told the jury on what they can consider and what constitutes evidence.
Again, Your Honor, I would suggest that issue about the preliminary instructions and what was given and wasn't given is not before the court.
I don't know why you're calling these preliminary instructions. They were the final instructions to the jury.
What I mean by preliminary, Your Honor, is at the beginning, before we get into the elements of a whistleblower claim and the intentional interference claim, the trial judge gives instructions to the jury about what they've heard. For instance, interrogatories in this case was a big issue that was discussed during the evidence. The judge explained what interrogatories were and that they could give weight to the interrogatories or they could choose to not give weight to it. I apologize for not having the exact instructions
this instruction that I read actually came after the instructions on the elements of a whistleblower claim.
Fair enough. Your Honor, I apologize. I do not have the instructions in front of me that the judge gave, but my memory is that he gave the customary, I call them preliminary, but the instructions that are given to the jury about how the trial was conducted, what testimony is, what deposition testimony is, what interrogatories are, and how the jury could give weight and other weight to them. I believe there also was a discussion in that sort of initial stage about circumstantial evidence and direct evidence. If I'm wrong, then
I didn't see it. Can you tell me a page number where that occurred?
I can't, Your Honor, but I can certainly submit a supplemental brief if it would please the court.
It's not the kind of thing that you submit a supplemental brief on.
Well, then I'll stand by what the record says on that issue, Your Honor.
Counsel, there were also printed instructions that the jurors received?
I believe there were, Your Honor.
Do you, I'm just wondering if the printed instructions were the same as the ones that were given orally. I mean, was that your understanding that
They tailored pretty closely to what the judge gave orally, what's in the appendix as far as the written instructions that were given to the jury. And my memory is that they were actually presented with those instructions when they went into their deliberations. I know that in some instances, courts will record the instructions and send them in. I don't believe that was done in this case. And there were no questions that came out during the deliberations about the instructions themselves.
Just to be clear, Mr. Notice, you may not submit a supplemental brief. You may submit a letter pursuant to 16L with citations to the record as to where the jury instructions to which you referred appear. That letter shall not contain any argument.
Thank you, Your Honor. I think that one of the arguments we presented in the brief was that drawing too much attention to this and the way it was framed and presented to the judge during the charge conference would have been prejudicial to the defendant and would have highlighted the proximity issue as almost cast as a, if you find it was close in time, therefore you can find and you must find that there was retaliation, instead of a gentler instruction that maybe didn't put it in such required language, such as, if you find that there was a protected activity close in time, you may draw an inference. Not that it's required or it's permitted. The instruction itself.
I couldn't find in the record, was that a written instruction that was requested? Was the request in writing to the judge?
Yes.
So I didn't see that in the record. Is that there?
I don't believe it is, Your Honor. I know that it was in the appellant's brief is where I saw it. And so I think
if the case was, if the case was that the language needed to be nuanced, wasn't that the more appropriate thing to do under the circumstance rather than simply rejecting the request for the instruction?
Well, it could have been argued by the appellant, and it wasn't. It was simply, this is it. There was no discussion during the charge conference of making it, of tailoring it a little more closely. In the Mole versus University of Amherst case, the court talked specifically about the danger of making this inference and the fact that you might have a jury conclude that merely because an employee makes a complaint close in time to when an adverse employment action happens, that's simply not enough. That what would be the result of that? The practical result of that would be any disgruntled employee could simply make a complaint or report a crime that they may or may not believe is legitimate to insulate themselves from some sort of adverse employment action. And that would hamper employees from administering proper discipline under the circumstances. And so the court needs to balance those things as he was.
I'm looking at the instruction that was quoted in the appellant's brief, and it doesn't say must draw that inference. It says may.
I think it says.
You are permitted to infer retaliation from the timing and sequence of events. The inference may be drawn if adverse action is taken against a satisfactorily performing employee in the immediate aftermath of the employer's becoming aware of the employee's protected activity, or where adverse employment actions follow close on the heels of protected activity.
And what I find objectionable is that you are permitted to infer, Your Honor, instead of you may infer in that first sentence. And that's what I think highlights to the jury that this is sort of a compulsory type of finding that they might make, that merely because something is close in time, well, you must infer that that this was a substantial and motivating reason for the discipline. In this case, the change in the job description that was offered to Mr. Ralph. You know, at the conference, it was very clear at the charge that the defendant objected to it, found it prejudicial, it was not in the instructions, and that the plaintiff could have argued it, and the judge specifically instructed counsel to argue it, and it simply wasn't argued strong enough. This is not an abuse of discretion by the judge. He sat through the evidence. The first question on the verdict slip was did the plaintiff engage in protected activity? That was not something that was stipulated to by the defendant at the trial. It was in dispute. And so whether or not he actually complained about the Siemens project was a big piece of evidence that was in dispute, particularly by Ms. Turkelson, who was at that meeting where it occurred, who said, I knew nothing about the Siemens project, and rejected the notion that Mr. Ralph actually complained about criminal activity or some kind of misconduct with respect to the Siemens project. So the judge clearly could have said, look, I think the Siemens project is in great dispute. If I instruct the jury that to highlight that, it's going to cause prejudice to the defendant. The better course of action here is to let plaintiff's counsel argue this in a nuanced fashion in the closing argument. He elected not to do that forcefully, and that's why it wasn't presented to the jury in the view of the appellee. So I'll concede the rest of my time unless the court has further questions.
Seeing none. Thank you. Thank you both. We'll take
Thank you.
this under advisement. Our next case is 21P439, CAPUTO versus McCarthy. Mr. Berluti.
Good morning. May it please the court, my name is Robert Berluti, representing the appellants Louis and Michael Caputo. This is an appeal from the Superior Court's decision dismissing their complaint as moot regarding their removal as trustees. The core legal issue is whether the basis of that removal can be based upon the best interests as determined by the beneficiaries, instead of viewing it through the lens of the settlor. The trust in question was specific that a trustee may be removed for reasonable cause. One of the 13 sections of reasonable cause was where it appeared to be in the best interests of the beneficiaries to have only an independent trustee serving. There was no definition of the term independent trustee. There were many definitions, including disinterested trustee, including an independent special trustee, but no definition of independent trustee. The beneficiaries
Can we start with the issue of standing?
Sure.
You did not file a reply brief, and so I don't think, right?
We did not, Judge.
Okay, so so you haven't responded to the argument made by the defendants on standing.
The Capo Bianco case that they principally rely upon for understanding issue, Judge, is very different factually from this case, insofar as
How so?
because the removal action brought by the trustee, Dennis Deschino, was brought first. There were counterclaims brought by the trustees in that case. Subsequently, approximately 2 years later, the trustee brought a claim specifically with respect to the interim provision. And it was with respect to that specific provision that the appeals court found in an unpublished decision that the trustee did not have standing in that case because they had no interest in the trust property, the trust corpus itself.
So you would agree that the plaintiffs here do not have any interest in the trust corpus.
We do agree with that, Judge.
Okay, I
We
mean,
do
that
agree
seems
with
to
that.
me like a given. Do you also agree that the trustees, it would be more customary for trustees in the circumstances in which your clients found themselves to file a complaint for instructions in the probate court?
I don't agree with that for this reason, Judge. It was not just an interpretation of the trust itself. There was some extra judicial documents, if you will, or extra trust documents, that is, the removal documents that were utilized by the beneficiary.
Why is that not just part of the interpretation of the trust?
Well,
if you were just looking for don't you first need just an interpretation of the trust provision, the provision of the removal, and get an instruction as to what it means?
Respectfully, I don't think so, Judge, and the reason is this. When my clients found out about this effort, there was another trustee already involved, People's Republic. So the question was, who had the status, People's Republic to act as a trustee or Louis CAPUTO? Michael CAPUTO was not a trustee at the time. He was a designated successor trustee. It never came into play.
How does he have standing?
Well, he has standing, Judge, because he was removed he's named under the trust. He has standing because the settlor obviously wanted him to serve under certain circumstances, and they brought him into it by removing him before he even served as a trustee. So the point is that there was an issue as to the People's Republic Bank or Louis CAPUTO, and the specific issue on top of it was that the custodian of the trust corpus...
Can we go back to Michael for a minute, the
Sure.
son? I don't remember the names that well, the son.
Sure, the son.
Under declaratory judgment action, you need to show some kind of injury, right?
You have to show a controversy, I believe.
Controversy, but don't you need, in order to have standing, don't you need to show some kind of injury?
Well, Judge, I think the injury here, I'm not sure you do. I think you have to show a controversy.
Okay, assume that you do have to show some kind of injury. What would be Michael's injury?
He was deprived of the opportunity to serve as successor trustee as the settlor, a woman that he had known for approximately 20 years.
Okay, so what's your best case? And for this, I'm looking for like case law, that kind of an interest is sufficient to confer standing.
I would say the Claflin case. Excuse me, the Claflin case goes back more than 100 years, and it goes to the question or the proposition that is the intention of the settlor that should get, that should be the governing, the guiding light. I would also look to the Uniform Trust Code itself that has the provision under terms of the trust. And the terms of the trust it's what the settlor's intent was as divined or as determined from the trust document itself. It's a rather unique proposition that there can be a non-judicial termination of a trustee or successor trustee's status without any consideration by the court. I'm not aware of any case that stands for that proposition.
Is it your view that the judge determined that the controversy is moot?
Is moot? Yes, I think I think she said that.
You think she found mootness? Because I was a bit confused by what the judge was saying.
I was too, because she...
Where do you think that she says that I'm dismissing it because it's moot?
She made a reference to it early in her decision, Judge, but later on, when she actually goes through the analysis, she doesn't seem to stand on the mootness issue. I think she, I'm just reviewing it quickly now. What she says is that because the first removal documents were then superseded by the second removal documents, then the second removal documents it doesn't matter whether or not the first removal documents were valid or not. That's the part that she says is moot. But she ultimately finds that the second removal documents were effective. And we're saying that those are defective as a matter of law because the basis of it was that the beneficiaries determined in their own best interest to take the action they took. And when you consider that what they did in the second removal documents was not only to remove Louis CAPUTO as trustee, they then also removed People's United under the exact same provision because they deemed it to be in their best interest. And they left a co-trustee, Denise McCarthy, as the sole trustee. And what that does is basically render the provision under the trust that the beneficiaries could remove for no cause a trustee, but not more frequently than every 24 months. So under their interpretation, under the beneficiary's interpretation of the trust, they could determine it to be in their best interest as frequently as they wanted to remove trustees. And under their best interest, they determined...
Well, I think what they're saying is they can do that as frequently as they wanted if they have, if it's for cause, and, but for no cause, that the 24-month restriction only applies to the no cause piece.
Well, but respectfully, Judge, the only way you can reach that conclusion in terms of their interpretation is to adopt their rationale under that Section 12, which says, where it would appear to be in the best interest of the current beneficiaries to have an independent trustee serve as a sole trustee. And so, you know, who is to determine it's in their best interest? What constitutes their best interest?
Well, wait, before you shift to another part, I'm looking at Record Appendix Volume 1, page 482. I'm looking at the trust itself.
Yes.
And this is page 12 of 31 of the trust.
Right.
Trustee removal provisions?
Yes, Judge.
Okay. So I take it we're talking about subsection B,
Yes,
because this is after the grantor's death.
yes.
I see a first sentence that says, a majority of the permissible income beneficiaries of each separate trust share who are of legal capacity or have legal guardians may remove a trustee for reasonable cause.
Right.
Then I see a second sentence that begins with the words, in addition. And it says, a majority of the permissible income beneficiaries of each separate trust share who are age 35 or older or have legally appointed guardians may remove a trustee for no cause. And then there's a parenthetical after that, but not more than one within a 24-month period. And is it your contention that that parenthetical applies to the first sentence as well as the second sentence?
My contention, Judge, is that the definition of reasonable cause is then set out in paragraph D.
Okay, again, my question must not have been clear, but it's very helpful if you can try to answer the question I'm actually asking. I'm not asking about the definition of reasonable cause. I'm asking about the parenthetical in the second sentence of this subsection B. You're with me?
I
And
am,
I'm
Judge.
asking you whether it is your contention that that parenthetical applies to removals under the first sentence of subsection B as well as the second sentence.
Not in all circumstances, it's not, Judge, and I
Okay.
don't mean, okay.
So we only have one no-cause removal here, and that's the one for Michael. Was he, and as far as I can tell, that only happened once.
Yes,
Okay, so I'm not really sure what the issue is with respect to the 24-month parenthetical.
the point is, Judge, is that when you harmonize all the provisions together, and that's why I don't think you can take that parenthetical out of context, or the provision or the provision for no cause has no meaning, because they can determine at any time they want, if you accept their analysis of this, that it's in their best interest, and they've given no best interest. Certainly no best interest as to People's United Bank. They had just designated them months earlier.
I mean, I think we'd have to agree that your clients don't have standing to pursue a claim that People's United was improperly removed as trustee.
That's right, we're not,
Okay,
right.
so, I mean, let's just set that one to the side.
Except that it's relevant, Judge, to this extent. If they're removing Louis Caputo under this reasonable cause because of their best interest, and then removing People's United within a matter of months because they deem it to be in their best interest, that's exactly making the point of why their interpretation of the trust vitiates and undermines the intent of the settlor. The intent of the settlor, I think, when you read all these provisions, was Louis Caputo. If he fails for any reason, resignation or whatever, then Michael serves. The beneficiaries are given the opportunity to appoint someone to serve as a co-trustee along with the disinterested trustee. But what they did was you just do a step thing. They appointed a co-trustee, which the probate court acknowledged. Then they removed the settlor's appointed trustee. And they can only do that either for reasonable cause, and that has to be established, and we submit has to be shown, has to be proven to a court to make that determination, or without reasonable cause, for no cause, but that can only be done once every 24 months. So if they cannot establish reasonable cause, what they did in removing Louis Caputo was two-pronged. They said it was for reasonable cause, and they cited two different provisions, one of which was this because they deemed it to be in their best interest. For Michael, they said, well, you haven't accepted an appointment yet, but if you do, we remove you as of that time. That's a prospective removal, which I'm not sure the trust contemplates either. So in any event, when you read what the settlor was looking for, what the settlor intended, and what they have actually done in this case, it undermines what the settlor wanted. And the trial judge's determination that what is in their best interest is a determination to be made by the beneficiaries without a judicial assessment.
We're going to have to leave it there, Mr. Belluti.
Okay, thank you.
Ms. Minchoff.
Good morning. India Minchoff on behalf of the trust beneficiaries. Judges, if I may, I'd like to state one thing, I think, from the onset. And I think this separates this case from almost all the cases that were cited by my brother counsel on this point in his brief. We actually have a trust document that prescribes specifically how the beneficiaries remove a trustee outside of the judicial system.
Can you just hold on there?
Yes.
So I think, in my humble opinion, you're confusing a couple different things. It is perfectly possible to have provisions of a trust that permit either the beneficiaries or the trustees to take actions without court intervention beforehand. That certainly seems to me to be the case with this provision. But what you haven't cited, and I am unaware of is any case that says that that action, once taken, is insulated from judicial review.
Okay. Let me address the court's point.
Do you have a case?
I have a case with respect to standing of that action.
No, I'm asking for the case for this proposition that which you appear to be arguing, which is because the beneficiaries are allowed to take action under the trust without coming to the court first, it means the court cannot review that action afterwards.
Well, that's actually not what I argued with respect to the motion to dismiss, and that's not what the court found in allowing the motion to dismiss.
Then what do you mean by not, so is that not your position?
It is my position that the beneficiaries don't have to ask for a court blessing before taking the action.
Beforehand, that's correct. But are you also arguing that their action is then insulated from judicial review?
I am arguing that if a trustee seeks to have a review of the action undertaken by the beneficiaries,
By the court.
seeks judicial review of the action undertaken by the beneficiaries, correct? That the first question is whether there is standing of that trustee to
Fine, so
seek
you
that
agree
judicial
that the
review.
court had, nothing in the language of this trust precludes the court from reviewing the propriety of the beneficiary's actions?
Within the four corners of the trust document, I agree with you, Your Honor.
Okay, great. So that's very helpful to me. So in order to review the propriety of the beneficiary's actions, it seems to me the court needs to have information that's outside the four corners of the complaint.
So I'm not sure I agree with you on that point. And
Why?
maybe if I
How
can tell
else
you-
is the court to know? Because if we accept it's a motion to dismiss, no one seems to have briefed this below or here, or, I don't know, acknowledged it, that we take the allegations of the complaint as true on a motion to dismiss. And to know whether there was reasonable cause to remove the trustee, and all we can look at are the allegations of the complaint, how is this
Sure.
properly dismissed?
Sure, because when you look at a jurisdictional issue, and that's what it does attack, is when you're looking at a complaint or a motion to dismiss based on subject matter jurisdiction, the mootness, then you do go beyond the four corners of the complaint and you look at what's attached.
This is what the trial judge called the paradox, or a catch-22, I think essentially the same
I
idea.
think so. I think that's what-
Wait, hold on. You say they don't have any interest in the cognizable interest from a standing or subject matter jurisdiction point of view because they've been removed, where what they're trying to challenge is the propriety of the removal, which I think you conceded they could. So if they don't have any interest because they've been removed and they want to challenge the propriety of the removal, why isn't that a paradox?
So I think that my point is actually being missed, and I think the trial judge actually got my point. I argued on the motion to dismiss the lack of an actual controversy in existence. I argued that for two reasons, that there was now a second set, let's say, of removal documents, which, and I find this very significant, and I can cite the court to the
If the second removal was improper,
they weren't contested by the defendant or plaintiff, excuse me.
if the second removal was improper, how does the court, what happens to your argument that this is a subject matter problem?
It's still a subject matter problem because the complaint sought to attack the first removal documents. At the hearing on the motion to
Then on the
dismiss.
second amended complaint, right, it also deals with the second removal.
No, it does not. No, it does not, and that's what's significant. And the court
All right, so I
asked the
guess where that
plaintiff-
gets you then, logically, is another complaint that then attacks the second removal?
It does not. And so, and I'll tell the court, at the hearing, specifically at the hearing on the motion to dismiss, the lower court asked the plaintiffs in that case whether they were challenging the validity of the second removal documents. You're going to find that in the transcript on volume 2, page 466.
Right, but I saw that. But what I read that to be was the procedural components of the removal. I didn't see any concession at any point below that that there was reasonable cause. I didn't see that. I see the removal provision as having two components. The first being procedural, which is there needs to be a certain number of people, beneficiaries who vote. And the second being, the reasonable cause provision, and then which is defined in the trust. I'm really struggling with how reasonable cause can be determined by the four corners of this complaint.
So with respect to the clause that was actually utilized in the second removal documents, with respect to that clause and, perhaps that clause alone, okay? And I don't want to confirm that, like just that clause, but definitely that clause. This is the clause that, and you have to read it in conjunction with Article 8, Paragraph 11B, which says, first, we're giving the beneficiaries the right to remove. And part of that is for reasonable cause. Then you jump to D as in dog, and subsection 11 is very clear that this particular one has 2 points to it. It's one sentence, but it has 2 points. If the beneficiaries determine that it's in their best interest to have a sole. So this is what
It
separates
doesn't
it from...
say if the beneficiaries determine. What it actually says is, quote,
appears.
where it would appear to be in the best interests of the current trust beneficiaries to have an independent trustee serve as sole trustee.
Correct. And appears to be in the best interest
Well,
of.
the beneficiaries think that it might, maybe, I don't know. But that doesn't mean that the court cannot review whether that provision has been satisfied.
Well, it's an interpretation when you look at B, Section B, that's giving the power, B and C gives the power to the beneficiaries to remove. Then you go to this provision and you read the language of the provision, which appears to be in the best interest to have a sole independent serve. That is a power being given that is not subject to judicial secondary review in the language used in that particular provision.
What is the best case that insulates this kind of language from subsequent judicial review?
Yes, Your Honor, it's the Udis case, and I can get you the exact site for that case right now.
And says a court can't review what a beneficiary's done afterwards?
What it says in the language used in that case also had a trust that was very broad language with respect to, that's Udis, E-U-S-T-A-C-E versus Dickey, D-I-C-K-E-Y, 240 Mass 55, 1921. And in that case, the language that was in the trust was that the trustees or the beneficiaries could determine if they deemed it expedient to remove a trustee to go ahead and do so. And it was somewhat of a similar argument being made by the removed trustees that, oh, you don't have the right to do it, the trust doesn't allow you to do this, and, you know, we need to have this reviewed. In that case...
And the court said we can't, we don't look at this?
The court said the only thing that, under those circumstances, when you have broad language that can be reviewed, is whether that power is being utilized capriciously and arbitrary.
And that was on a motion to dismiss? Well, there wouldn't have been motions to dismiss then.
I'm not actually sure what the proper vehicle that brought it up to the SJC at that time was, or in the lower court. But that was the ruling of the court in looking at a broad language that gave the beneficiaries the right of removal. And that would be very consistent with what has happened here.
There was no removal provision in that trust. I'm looking at the decision right now.
There actually, Your Honor...
They asked the court to come by implication.
No, it says the power of the removal, it was actually a deed of trust, and the power of removal of the trustees was an essential part of the trust deed. The words of the trust deed are that the vacancies in the trusteeship may be declared for such reasons as to them they may deem expedient. So that's particularly part of the case. That was the gist of the case. And if I recall correctly in some of the facts, I think like the original, this was a church, and maybe the original board had been removed. And so there was a secondary question as to whether, since the body that had been empowered to remove no longer was organized, that how could this be utilized? And so that was a secondary question, but a primary question was actually looking at the terms of that trust of deed, and what the power was that had been granted as far as the trustee removal. And the word expedient, I would say, is somewhat analogous to the word appears. And so the court went through in some detail saying, hey, we're not here to second guess. Even if we were to say we think it's more prudent that you keep these people in place, and in fact, they only removed one of several trustees, even though the same grounds existed for all the trustees in that case. But in any event, the SJC says we're not here to second guess your decisions on what you find expedient. This is a broad power given to you to remove, and even if if we were to deem differently in our view, through the lens that we're looking at it, we can't do that. We can't trump what you say, because if we want to talk about intent, this was given to you in the deed of trust, and you exercised it, you utilized it. We're living, the trustees need to live by your exercise of it. So that would be the case that I find most on point, Your Honor. So if I may, I think what the lower court did was say, okay, I need to determine whether there is an actual controversy that's still in existence here. And what she did is she reviewed, the lower court reviewed essentially the different provisions of the trust, saying, this document isn't being contested here today. The amended complaint is not contesting the second removal documents. And I will let the court know that the amended complaint or the...
Do you read the judge's decision to have decided that the controversy was moot?
The underlying controversy is set forth in the complaint as being moot, yes.
You do? Can you point me where she says that in her decision?
That's going to be on page 10 and page 11, Your Honor, of the court's decision. And specifically, she starts off, I believe, on page 11, saying the beneficiary's mootness argument. And this is where she cites to the paradox of how do I determine it's moot without first actually reviewing the subject or taking subject matter and reviewing the different provisions of the trust. So she's...
But she says, for the above stated reason, the court declines to analyze the beneficiary's motion solely as a matter of subject matter jurisdiction.
Well, I think that's because she felt as if she had to take subject matter jurisdiction to review the actual issues, to make a determination as to mootness.
Seems to me she focuses on what Justice Meade was focusing on, that you can't show that it's moot unless you can prevail on the merits. And that's a really weird way of determining mootness.
I don't think that that's what she did. I think
Well,
what
that
she
is
said
what she
was...
says. That's what she identifies as the paradox.
I think she had to make a determination with respect to the interpretation of the trust. And so when you look at the rest of the analysis, she repeatedly goes through and talks about the provisions of the trust. So for instance, let's just say...
Yeah, which is, I think you're trying to prove too much, right? You're the appellee. You only have to win on one ground, not all of them. So what the judge said was your mootness is a paradox. So she's not going to address it. She said that she also was going to second guess what the beneficiaries thought was in their best interest, and found that the removal was proper. So no need to tilt against windmills.
I will conclude unless there's any other questions with me on that note.
Well, if she did, as I happen to agree with Justice Meade's reading of the judge's opinion, if we are correct in that view, then it seems to me this is not a 12B1 motion, this is a 12B6 motion.
So I will say to the court that I think that you could view it for the same outcome on both, and as this appellate court knows, any rational reason supporting a decision by the lower court should be upheld. And I just want to repeat again that they didn't contest these documents, either the second removal documents, either at hearing or in any underlying pleading that is before the court. So,
We're going to have to leave it
okay,
there.
thank you.
Thank you. Thank you both. We'll take it under advisement. Next case is 21P 838, Michael Vellotti versus Anthony R. Vellotti and another. Mr. Tarlow.
May it please the court. My name is Dan Tarlow. I'm here for the appellant Anthony Vellotti. And I have asked the court in my brief and in the appeal on behalf of my
Wait,
client.
I'm having trouble hearing you. Could you please speak up or move the microphone closer to you?
My apologies. I think my height works against me.
I know.
I'm asking the court to focus on the statute of limitations issue as outlined in my brief. And in particular, I would focus on the MUPC section 1005 and the section that would have the trial level court focus on The motions to dismiss is filed by the appellant on when the plaintiff reasonably should have known that he had a cause of action. And in this case, I would suggest that April 11th, 2014 is the outer limits of when the plaintiff reasonably knew that he had a cause of action. He is not.
Is that when he was told the funds were depleted?
That's when the account was closed and he was told that the funds were depleted. I would suggest that the record's not
But I'm
entirely.
sorry, I had a follow-up. He was not told who depleted the funds at that point.
Correct.
So why would it run from that point when he didn't know?
The factual connection of the history of the case is, if you go back to November of 2009, which is the errant agreement that his brothers, John, I believe, had drafted, and both the plaintiff whose case survives and his mother signed. And the court found that had no legal effect, and I understand that, and that's not before the court. But the factual nature of he knew that his brothers were going to be taking money out of it is embedded in the knowledge of Michael VELLOTTI. So in April of 2014, after the payment stop in March, a month before, and his own testimony, as I recall, was something to the effect that he knew that when the trust ran out of money, the trust was terminated or it was over. So the payment stopped in March of 2014, and then on April 11th, the account is closed. I will concede that it's unclear that on that exact date he was told the account was closed, but it is very shortly.
May I ask
time.
you a couple things?
Yes,
He is not an account holder on this account, correct?
correct.
Only the two defendants were account holders? Because the account was in the name of the trust, and they were the only two people who could withdraw money from the account, is that correct?
That is correct.
He wasn't making his own withdrawals from the account?
That is correct.
Okay, he didn't receive bank statements?
I would say the evidence, he did not receive bank statements. I can concede that, yes.
So it all goes back to, in those circumstances, this is not an account he has control over, right?
Correct.
He's not being given accountings along the way or being told by his brothers what the balance is.
I can concede generally, but I don't concede that point near the end of the trust, because I do believe there's evidence about discussions in March and definitely in April when the account is closed early, just
Can
on the 11th.
we agree that he's never told that his brothers are taking money out of the trust account for their own purposes?
The 2009 document that they signed, which again is not before, gave him the information that his brothers were in fact taking money out, but I would concede that he was not given an accounting as to how much and when. So, but, when we're talking about the statute of limitations, right?
So you think his claim accrued when he knew that the account was closed?
I believe that yes, on or
Because from that fact alone, that would put a reasonable person on notice that money had been improperly withdrawn from the account?
not from that fact alone, no.
Okay, so then how does his claim then accrue from that date?
2009, he's aware that his brothers are going to be taking money out of the trust, the reference to the $50,000 and the money around the gifts.
Can I stop you there?
Yes,
So the trust document permits the brothers, who are trustees, to take money out.
correct.
It doesn't permit them to take money out for anyone's benefit other than Michael.
Correct.
So he would not be on notice in 2009, based on the wording of the trust, that they can take the money out for their own benefits.
But I suggest he was on notice from the, albeit misguided, document that he signed that was submitted by his brothers in 2009, in November. So, embedded in his knowledge in 2014 is the fact that he did sign a document where his brothers were going to be taking monies out in contravention to the terms of the trust. Again, it's not an issue ripe for appeal, but just as...
For a single purpose, right, at that time?
My memory of the document was...
What page, where do we find that document in the record?
If I can find it very quickly in my statement of facts, Your Honor. On page 8 of my brief, what I cite to is on, that's the first modification, excuse me, hold on.
This is maybe on volume 2, page 445, the Vellotti Exhibit
Yes.
4 at trial.
As referred to in exhibit, page 9 of my brief.
Just says the Vellotti Trust will pay a sum of $50,000 to each of the trustees for management of the Vellotti Trust and as family gifts?
Yes, Your Honor, and this sum will be paid in payments over a period of time.
So this, and is it your argument that this gave him notice that there would be more than $50,000 withdrawn by the brothers for some purpose other than for Michael's benefit?
No, Your Honor.
Okay, so what puts him on notice of that fact?
My best facts, supported by the record, are as follows. The document we just talked about with the $50,000, which puts him on notice that some money is coming out. The next fact is the closing of the account, which I believe the record, the testimony at trial was that he was aware that that when the payment stopped, that the money had run out, and then the discussion with his brother letting him know that he had closed the account, which happens on or about April 11th, 2014. When you put those facts together,
That should have put him on notice that the brothers had been taking money out of the account for improper purposes.
a reasonable person would say, would know how much money was in the account when it started, and would question why the payment stopped and why the account was closed.
Okay, and do we take that from a reasonable person in the plaintiff's shoes?
I would suggest it's an objective standard, but I cannot point to a case that would tell you that.
Okay, and that would mean that we would take into account a reasonable person in the plaintiff's shoes, which included that he has developmental disabilities?
I would suggest, statute says a reasonable person or that person's representative, and that he had persons around him would be the best facts to support my argument that yes, the statute would have started to run on about April 11, 2014.
So we would have to say a reasonable person with developmental disabilities would have taken that constellation of facts and been on notice that he had a claim against his brothers for breach of fiduciary duty.
I don't believe I concede that it's a reasonable person with developmental disabilities. I believe I would suggest a reasonably prudent person would be more of an objective standard as far as...
It's an objective standard in the circumstances presented.
Yeah, I believe I have to concede that, Your Honor, yes. So that would be my argument, that under those circumstances, under the statute, in that the court focused more on the old doctrine of repudiation, which I believe is, I would suggest is not explicitly, but abrogated by the implementation of the MUPC in 2012. And then my fallback argument, Your Honor, is to focus upon the terms of the trust itself, where the liability of the defendants here should not have been joint and several because of the addition of the word responsible to the trust. That while I understand the court's thought process of joint and several liability, but because the trust expressly provides for separate responsibility, that the court should have parsed out the actual benefits, and the case should be remanded for further decision on that issue. If there's no further questions from the court, I'll yield the rest of my time.
Thank you.
Thank you.
Mr. D'Angio.
Good morning, Your Honors. My name is Carl D'Angio. I represent the appellee, Michael Vellotti. I'd like to just start off by dealing with some of the factual arguments. Not that I dispute any of the specific facts my brother just made, but this was a trust that was in existence for the better part of 15 or 20 years. The first part of which there was just the house, and Mom and Dad collected the rent, and thereafter the house was sold, and I believe it was at least 7 years that Anthony and John were administering this trust. During that time, the record is replete with lots of communication, particularly between Anthony and Michael, that Michael was spending too much money. There is no evidence anywhere in the record that Anthony, at any time other than that $50,000 discussion we're talking about, which the court invalidated under the spendthrift provision, saying that Michael didn't even have the ability to approve that, and that the trustees didn't have the ability to take that money for themselves. But in any event, other than that, the only thing that put Michael on notice was about 6 or 7 months before we filed the complaint here, and that is when John's son, who happened to live with Michael, said his father was feeling guilty. I'm paraphrasing, but feeling guilty about what happened with the trust. In the next few months, we met with Michael. We found it looked like maybe there was something there based on what Michael Menon, the nephew, said, and we filed suit. There was no accounting at all prior to when we filed suit. The real accounting here, Your Honors, is when we subpoenaed the bank records. We found check after check signed by both Anthony and John just giving themselves money. I think it's relevant that Michael is a special needs adult. He works and so forth. His mother now is a 102-year-old Italian immigrant who can't really read and write in English at all. So to say that Michael was on actual notice or even reasonable notice that anything had been done wrong other than, hey, Michael, the money finally ran out. I told you the money was going to run out. They met with Loretta Wakeham, who's Michael's alternate mother, so to speak, and at that meeting, Anthony admits in his testimony, I mentioned how much Michael had spent. He didn't mention anything about what he had spent, nothing. He promised that he would provide an accounting, testified at trial. He said he sent an email, but he never sent an email. I can check my emails back 10, 15 years, and they're there. There's no evidence at all Michael ever received an accounting, and there's no evidence that a reasonable person in his situation would be on notice that there was anything done wrong here. There was no accounting, there were no bank statements other than that last bank statement that says, the account is zero, Michael, sorry, you spent all the money. So I think everything in the judge's decision is rock solid. I had to work hard to think where there's a legitimate dispute on these things. Clearly, throughout the proceedings, they preserved the statute of limitations argument, but preserving it doesn't make it valid. As far as the joint and several liability, the law is pretty clear that you can't use the language of a trust to defend you where you've committed malfeasance. This is basically a conspiracy together. They both just decided that they were going to take these monies. At trial, Anthony tried to change his tune and say that this was money that he had earned for representing the trust and as a trustee. But throughout his deposition, he said this was money he felt he was entitled to. This was his inheritance, and he said it at least 4 or 5 times. In cross-examination at trial, it was made clear that this was just a new theory. I'm not sure what else I can add, unless you all have some questions. I would ask, Your Honor, that I believe the appeal is not a good faith appeal. I would ask that Your Honors order costs and fees for having to come here. Thank you.
Thank you. Thank you both. We'll take it under advisement. We're going to take a short recess.
All right, please. is in recess.
They were in the back doing a...
Test, check.
Yeah.
It's working. Test, check 1, 2.
Our next case is 21P987 REEM Property versus Transfer Financial. Mr. Roberti.
Good morning. My name is Jim Roberti, and I represent the defendant appellant here, Transfer Financial LLC. The question before you today is whether the appellate division erred in affirming the trial court's finding that the plaintiff appellant REEM Property LLC did not waive a times of the essence clause in an agreement to purchase property at a foreclosure sale. Transfer maintains that, one, REEM did indeed waive the time of the essence clause because expressly and impliedly REEM's counsel's words, actions, and pattern of conduct both before and after the expiration of the times of the essence clause demonstrated that he was not holding to the stated 12 o'clock closing time on June 30th, 2014.
Do you think that this is a question of fact, a question of law, or a mixed question of fact and law, whether there was waiver?
Okay, so there's a footnote that I found when I was preparing again that the judge also cited in the original decision. In the case of McCarthy versus Tobin, footnote 5 says, the issue of waiver is ordinary one for the fact finder. If the facts are undisputed, however, waiver is a question of law.
Right, so the judge has to make subsidiary findings, and then the application, it seems to me it's like a mixed question of fact and law.
Right,
Because
yes.
first there have to be the factual findings, and then the application of those facts to the law. So I didn't see, and maybe and I hope you'll correct me, I didn't see that you're arguing that any subsidiary finding of the judges was clearly erroneous.
So when you say subsidiary findings?
I'm talking about such and such email was sent at this time
No,
on
I'm
this
not
day,
disputing that.
and it contained this information.
No, I'm not disputing that.
All right, so the underlying subsidiary facts seem to me to be undisputed.
Yes.
And so I guess your argument is, as a matter of law, those constituted waiver?
Yes, because there were no telephone, it was interesting, no telephone conversations whatsoever
And maybe
between the
someone should have
parties.
picked up the phone,
Right, I understand. But
practiced
for
it.
our purposes, it's everything that's in the record is the record.
Everything that's in those email exchanges. So what did seem to me to be a distinguishing feature of this case is that the email exchanges did not appear to be modifying the terms of the agreement.
No, it's certainly just about
It's about
closing
making
process.
sure, yeah, making sure all the documents that were necessary for it. So what's your closest case where the back and forth is not actually trying to modify the terms of the agreement, and that nonetheless the court found that there was a waiver of the times of the essence clause?
Yeah, I was trying to chart that out this morning, because most of them are about whether P&Ss are failed and don't get from the OTP to the person's settlement.
People are still working out the
Right.
details of the
I
deal.
guess the closest one would be the Church of Christ case, I thought. Church of God in Christ versus, this one here, Church of God in Christ.
You cited it in your brief, I believe.
Congregational, where the people had gone into the contract already, and then there were these actions after the contract was signed that imply that there was a waiver, and the court found a waiver in that case.
But weren't they still negotiating some of the details of the deal?
No, I think one of the things they found is they got a variance or something like that, for a special permit, and that they were slow payers, and that they kept dribbling out money. It was one of those cases where it was going from a synagogue to an African-American church, and they were trying to work with each other, and then at some point, they weren't. But then the court said, well, there's so many things that have happened post-agreement that you end up, there's a waiver here.
And how do you say there's an analogy here?
Well, the argument that it's the closest case really because all the other cases are about failed agreements that didn't even get to agreement. So the issue that I was having with this and that why I was differing with the judge in the appellate division is the idea of duration to me. I also am a practitioner. So it didn't have, in that case, the one I just cited, that was a long period of duration. And but I don't think you need that. I think that...
But isn't that sort of the essence of the time is of the essence clause to signify that maybe a little bit... Well, you're trying to say that even though you have a time is of the essence clause, a little bit over the time is okay.
Well, I don't think I'm saying that when Hale gave him, the attorney for REEM gave him the edits 13 minutes before the time and told him what he needed to do, and then time went by. When the time went by, that's when the waiver occurred. And then it's bolstered by the fact that they continued to talk for a little bit, into the afternoon, 1:30, 2, and then by 3, it was already by 3 when he says, when Hale says, deal's dead, because he then had a chance to confer with his client.
But wasn't there the very first communication after the time had passed, the rights were reserved?
Right,
Sort of reminding.
I just don't think you can reserve something you've already waived.
But does waiver work like that in this context? Isn't it incumbent on the party to say, listen, we're obviously not going to make the noon deadline, let's agree to an extension?
No, absolutely not. Because it happens all the time with different contracts. You can have a person's building a house and they don't meet the date. The builder doesn't, but then they continue with the house, and then the buyer gets upset, a couple of days later and says, hey, I don't want to buy it anymore. But at that point, they've already waived the closing date. So here, the same thing. When he went, he should have said it.
Does the waiver need to occur before the required time?
No, the waiver occurs once you miss the time. Sort of like.
Okay, are you contending that there was a waiver before noon?
I'm contending that when you hit 12:00, whatever the second is after that, and you don't say this deal is dead, because he could have said that.
Then you've waived it?
You've waived it. Because
Why isn't it that when you hit noon, it's not dead just by operation of the terms of the agreement?
Because that's the implicit issue. It's implicit. You haven't done anything positive, but you also haven't terminated. You've just done nothing.
If you hit noon, and then there's no further communication.
Correct.
Your client would have to return the deposit.
Right, but there was
right?
further communication.
Okay, but I'm just trying to figure out something that maybe is only a question in my mind. So you don't need to, the deal sort of automatically expires of its own terms at noon. Unless there's a waiver either before or after, I guess.
Right.
So are you contending that it was, I guess you're contending that the entire string of communications constituted the waiver?
Mm-hmm.
Even though there's no explicit waiver?
Right, but you're never going to get that usually.
Well, I could easily imagine a circumstance where someone writes to the other and says, doesn't look like we're going to get this done by noon. Shall we extend it till tomorrow? And they'll say yes.
Right. Or alternatively, they could say, we're not going to get this thing done by noon. I'm just going to be fair with you, we're canceling.
Yeah.
But that didn't happen here.
But who has the burden?
The person that has the right to cancel, should.
Well, both parties have the right to cancel, no?
My client had no right to cancel. They were still endeavoring to get, they
I
were,
mean, if it doesn't close by noon, then they just have to return the deposit.
but my clients were endeavoring to clean up
Yeah, they were
the
trying to,
mistake.
they weren't ready to close at noon. That seems clear.
Correct. But they, as the afternoon wore on, they could have straightened everything out that day.
Well, no, except that it went into the next day, still, right? You said they would have been ready that day, but the communications
Right.
from your side continued until the next day.
Right, but they assumed they were working things through until were told like 3 o'clock.
Was that assumption reasonable, given the prior communications which stated my client reserves their rights?
Yeah, but I disagree in that I don't know if there was anything to reserve at that point.
Can you,
Should have reserved his rights at 11:47. But I think they were hedging their bets, hadn't talked to their client yet. Don't know whether I should cancel this, or should I go forward? All right, I'm just going to do nothing. And then I say when he does nothing,
Well, it's not
he's
nothing.
waived it.
It
So
was
then excuse me.
by reserving rights, it's not the same thing as doing nothing. It's putting the other party on notice that I need to talk to my client, but when I do, I may, this may not go forward. It may go forward, in which case keep going.
I just would say that he should have done that before the 12 o'clock. Said, hey, you're not going to be ready by 12. I'm reserving my rights here, but I can tell you that I'm not going to let you go beyond noon. This deal's going to die. But he's like, as my mother would say, having his cake and eat it too. He wanted to be right there in the middle.
is Transfer Financial what kind of business is it?
It was a LLC that was formed to buy a private lending company. So my client, who's the principal, is a private lender. He has several other companies that he had. And there was an older guy from Milford who was 82, 83, who had enough. And so he decided to close up shop and sell all his outstanding notes and mortgages, this being one of them. So my client probably bought 50 notes and mortgages and put them into transfer because he had partners that invested with him on it.
It's okay, I didn't mean to get into that
But that's
that
how it
level. I
works.
was just trying to find out, I mean, it wasn't like Citibank, it's not a
Oh, no.
big thing.
No,
But
no.
it is a sophisticated business entity.
Business guy, yeah.
Operating in
Yep.
this arena.
Yep.
Okay.
Was anything about this deal, I mean, was there any request that was unusual?
No, it's all timing, though. If you look at some of those cases, those foreclosure memorandum, not really like a purchase and sale. You have to close within 30 days of no mortgage contingency, none of that stuff's in there. And so it was like 24 or 5 days in, I can't remember, but it was late in the game, that the buyer's counsel contacted Garahan, seller's counsel, for the docs. So it's...
Right, but I see it as a two-way transaction. It's not sort of, you're saying, well, they were late in the game asking for it, but both parties have a responsibility to get this deal done, right?
Right, but I feel the onus is on the buyer to get started on this, because if he only has that 30 days, that's it, to buy as well. So there was one of the cases that I had from the land court said that, somebody who starts late and then, so they started on a Tuesday, Garahan didn't answer till Thursday, they worked Thursday, then nothing happened on a Friday, and then all the activities started at 10 o'clock on a Monday, hoping to all close by noon.
But what I'm saying is both parties had an understanding of what was required.
Right, but it's the normal practice to work these things through. There wasn't anything that was unobtainable. There wasn't any objections and fights about, oh, this isn't what I want. It's just a matter of ministerially getting it all together. So to say at 11:47, yeah, these are good, but we need this and this and this, and then to not say, and if you don't, well, the deal dies, and then at 1:30-ish to say,
But you always knew
I'm
that
reserving my
possibility.
rights.
When you said you always, because of the time is of the essence clause, the specific time that was set forth, you always knew that that was the possibility, right?
Right, but the course of dealings were not leading you in that direction. In real time, it's tough. It's tough it's easy for us here to say, yeah, but when you're in real time and you're answering 5 phone calls, plus it's 10, now it's 11, now it's 11:47, he wasn't thinking that he was going to have the deal die.
Okay, we'll have to leave it there. Thank you.
All right, thank you.
Mr. Summer.
Thank you. May it please the Court, David Summer for REEM Property, LLC. Unsurprisingly, I do not think there was any waiver by Attorney Mayo, who was representing REEM in this case. All of the emails, including the emails some the panel just mentioned, the 11:47 email, in that specific email, which is 13 minutes before, Attorney Mayo indicates that he needs these documents to close per the terms of the sale. And the terms of the sale was to close at 12 noon, and there was a time of the essence clause, and thereafter, and I think it's unreasonable for this court to come out with a rule that if there's a closing that is at 12 o'clock, that unless at 12 o'clock or at 12:01, you as a buyer have an affirmative duty to then send an email or make a phone call saying, well, it's now 12:01, the deal is dead. I think that's completely unreasonable. Attorney Mayo did respond to Attorney Garahan's emails, and Attorney Garahan
Well, I
sent...
think if you hadn't had the email before noon referencing reserving rights, this would be a much tougher case, because there is continuing back and forth, muddying the water after noon.
Right. And Attorney Mayo does indicate that he's reserving all rights. And then he talks to his client, REEM Property, and shortly after that email, within a matter of hours, he requested the deposit back. And thereafter, for Attorney Garahan to say, well, we don't know whether or not there's a waiver, let me continue to obtain these documents and work on this closing, is unreasonable. He clearly knew, even before he obtained any of the documents, that according to REEM Property, the deal was over and complete, dead. There was absolutely no indications from Attorney Mayo or REEM Property itself that there was any waiver in this particular case. So I think the fact that, I mean, there is a time of the essence clause, and Attorney Mayo was very clear that he's reserving all rights, that he wanted to close per the terms of the sale. At no time should Transfer Financial have believed that this would have continued on and on. And I think the question that the panel asked was poignant, which is that if there was no further communications and it hit noon, whether or not Transfer Financial would be forced to give the deposit back, and I think the answer that I heard was yes. And the fact that Attorney Mayo sends a subsequent email at 1:35 and says, you know, we still don't have the documents, we're continuing to reserve our rights, does not create any waiver after that. There's no waiver. And I just want to address one additional point, which is that the suggestion that my client had some sort of duty with respect to purchasing the property. When you are a buyer of a piece of property, it's incumbent upon the seller of the property to have the documentation necessary to pass sufficient title at the time of the closing. That's not the duty of the buyer. The buyer's duty is to pay the amounts that are due. The seller's duty is to have all the documents necessary to provide good title for the buyer. And I think it's abundantly clear that there is absolutely no waiver in any of the communications by Attorney Mayo in this case. I think it's crystal clear.
What do you say about your brother's argument that there were sort of new requests that were made last minute, sort of making this a fait accompli?
Absolutely. This is not a case, and I think the case may be the McCarthy case that has the PNS, where one of the parties undertakes completion of the PNS and they sort of delay, and that creates a waiver. In that particular case, they delay for weeks. In this case, I would disagree with what he's saying because of the fact that it's not my client's duty to provide, to say, well, we need these documents. That's the buyer's duty. The buyer has to show up with the deed and all the documents that are necessary to pass title. That's never on the, I think I misspoke, that's always on the seller to come with the deed and all the documents that you need to close, to pass good title.
So in making all of these requests, we need this affidavit, we need that, we need it in this form, you're basically facilitating the seller's responsibility.
Right. We're indicating to the seller, what we need for good title, but the seller should know these things to begin with. They're the ones that are passing title. It's not incumbent upon the buyer to provide instruction as to what documents are needed. Typically, the attorneys representing sellers know we need these documents to pass title. And there's, as far as I know, there is no case law out there that says it's incumbent upon the buyer as a duty to work with the seller to make sure they have their documents correct. If there are no further questions, I would rest on my brief.
Seeing none, thank you. Thank you both. We'll take this under advisement.
Thank you.
The next case is 21P478, Commonwealth versus Morales.
Okay, here's the podium. All right. I can take this off, right? I can take the mask off.
Welcome, Ms. Stefani. I'm Judge Meade in the middle. To my right is Judge Wolohojian, and to my left is Judge Singh.
Right. It's still morning?
12:05.
Adjust your mic.
Okay.
Okay.
May it please the court, my name is Lisa Stefani. I represent the defendant appellant Luis Morales in his appeal from his convictions. I'm going to make a somewhat different argument than I originally was going to do, because one of the things is that we thought, my main argument is that the trial judges who granted Mr. Morales' motion for required finding. And it's not just was presented at the trial, but the whole, no one really knows what happened on the night that there was the shooting. Because even though the Foote brothers entered into a cooperation agreement with the Middlesex DA's office, we don't know what really happened. Because they weren't totally forthcoming. There's some stuff on the record in this about the fact that they did not tell the prosecution that they were going to get married. There was going to be an exchange for marijuana and other things, and so no one really knows what happened that evening.
Well, we know that the two brothers were both shot, and we know that Sandro identified the defendant as the shooter.
Yes, we know that, but that's not the full story. Because they entered into a cooperation agreement with the prosecutors.
Was the jury told that, was there evidence that the two brothers had entered into a cooperation agreement with the government?
Yes.
So normally, wouldn't we say that the jury could add that fact into the mix when they were evaluating the credibility of the witnesses?
Yes, but I don't think, and then right after they entered into the cooperation agreement, they weren't totally forthcoming with what even we know now what happened. They didn't tell the prosecution. I don't, and I think the police knew after a certain point that they were going to exchange exchange with Mr. Morales the marijuana. And there were other things similar to that. I think one of the factual things that is underlying this, and keep this in mind, that Sandro, and the only way he knew Luis Morales was they were cellmates at the Middleton House of Corrections for, I believe 4 months. And right after they entered, I think it was Sandro entered into the, they weren't forthcoming to the DA's office. That's what, and there's many ways, we don't really know what happened.
The defense counsel cross-examined on all of these, along all of these lines, correct?
Yes.
It's really brought out where the weaknesses and contradictions were in the two brothers' various statements in grand jury and to the police and then at trial, correct?
Yes. But I also think that the motion for required finding was very general. It wasn't specific to what it was a general required finding. It didn't get into what I'm saying today.
What I understand your argument to be, but please correct me if I'm wrong, is that there was insufficient evidence to permit the jury to find that the defendant was the shooter.
Yes, beyond a reasonable doubt, yes.
Beyond a reasonable doubt. You're not contesting that there was sufficient evidence to prove there was a shooting. It was really, what I understand your argument to be is that there's insufficient evidence of identity, that the defendant was the person who was the shooter.
Yes.
Okay.
In so many words, yes. But there's only a few things we know actually happened. We don't know what really went on that evening. And some of the, and you know, the fact that that it came out that Mr. Morales and Sandro DeFoot were cellmates is, I mean, I just think that there's a lot of unknown things, what really went on that evening. We know that Luis Morales was there. We know that Sandro and Andy were there. But they admitted at certain points that they didn't tell the whole story to the
Well, they were admittedly trying to consummate a drug deal, so they're reluctant to cooperate with the police when they may, in fact, be inculpating themselves.
Did you repeat the question, please?
They were reluctant to be forthcoming with the police because they were afraid of being implicated in their own crime. But then that was worked out, and the jury was aware of that.
Yes, but I just think not completely, not exactly. And they admitted to not being forthcoming, but not. So what the inference is that they admit to being not forthcoming on certain things, but then there may be other things that they weren't forthcoming or weren't exactly what happened.
But those...
They didn't tell the full story about what was going to happen that evening. That there was going to be an exchange of marijuana, for one thing, for $2,600, I believe.
Okay. Is there something else you'd like to tell us?
No. No, I think that, thank you very much.
Thank you. Ms. Jansen.
Good afternoon. May it please the Court. Catherine Jansen on behalf of the Commonwealth. Commonwealth respectfully requests that the Court affirm the defendant's convictions because there is more than sufficient evidence of the defendant's identity as the shooter. Just Sandro's direct testimony alone, identifying the defendant as the shooter, is sufficient. Any issues of credibility were for the jury to weigh, and they were fully made aware of prior and consistent statements, the cooperation agreement, as well as other issues with their credibility, and the verdict suggests that they credited the testimony. If there are no further questions, the Commonwealth is happy to rest on its brief.
Seeing none, thank you. Thank you both. We'll take it under advisement. The next case is 21P593, Commonwealth versus Road. Mr. Hennessy.
Good afternoon, Your Honors, and may it please the Court. Robert Hennessy on behalf of James Road. Your Honors, this is an odd case. I know that you're aware of the facts and have reviewed the record, but I think it's worth mentioning this is the oddity of this case in that it's a prosecution for criminal negligence of a police officer who was, at the time, engaged in his official duties and responding to an emergency call. At trial, the defense was that the actions of then Sergeant Rode were A, not negligent in light of his official duties and the laws attendant thereto, or B, not the cause of the actual accident, that the cause of the actual accident was the driver of the car that Mr. Rode struck, resulting in the death of that driver. In closing argument, and I've raised three issues with respect to the fairness of the trial. The first is an argument that the prosecutor's closing argument went beyond the bounds of fair argument in this case. The second is that there was issues with the jury instructions, and the third being a cumulative error argument. But I'd like to start with the closing argument itself.
Can we talk about which of those arguments were actually preserved? Because as I see it, only the Andy Klain argument was preserved, not the cowboy or the blaming the victim.
Well, the blaming of the victim, I'm pretty sure, was preserved. It was actually disparaging the defense as an attempt to blame the victim, disparaging the Andy Klain being the expert, the allegation.
I mean, that is the Andy Klain argument, disparaging the expert, right?
I believe, I'll double check, but I believe that defense counsel actually cited the blaming the victim comments to the judge as part of his objection to the closing argument at trial.
Okay, go ahead.
But to your point, there was no objection to the characterization of Sergeant Rode as a cowboy at the very end of the argument. So I'll turn first to this characterization of the defense itself as an effort simply to blame the victim in this case, and not just an effort.
Mr. Hennessy, though, I mean, Mr. Reddington's whole argument was it was the victim's fault.
Attorney Reddington's entire argument was that on the issue of causation, there was an issue for the jury, and that his argument was that the evidence at trial established that at a minimum, at the time that this person would have pulled out under any analysis of the facts, there would have been at least a reflection of police lights on overhead wires that could have been visible at the time.
So Mr. Reddington said it was the victim's fault. He shouldn't have pulled out.
Mr. Reddington said that the decedent caused the accident. I think characterizing that as an effort to blame the victim is different in kind and goes beyond just commenting on the state of the evidence, but actually is an effort to inflame the jury in that context.
Well,
that is my argument.
He's dead. He is a victim.
I mean, we can quibble about whether or not in a case involving an allegation of criminal negligence
Well, it's motor vehicle homicide by negligence.
But, okay, the motor vehicle homicide by criminal negligence, that not every person who dies in that context is a victim of a crime. That was the issue before the jury, was whether or not the negligence of Sergeant Rode was the cause of this death and whether he should be held criminally responsible for that. I think characterizing this as an effort to blame the victim was putting the cart before the horse, is our position. And the other aspect of that is it wasn't just an effort to blame the victim, in the words of the prosecutor who, in closing argument, it was a fabricated effort to blame the victim. And that's the second aspect of the closing argument that I argue goes beyond the pale in this case, is that a couple things. I mean, first, just the tone, I think, needs to be acknowledged in terms of how the prosecutor was arguing this. These arguments were made in sort of the mock voice of the defense team speaking among themselves, saying, quote, "So you can't defeat the speed. How else can we shift the blame here away from Mr. Rode? Let's blame the victim. Let's blame the individual who lost his life and who's not here." And then they go on to say again, so the defense, not questioning speed, says, well, we've got to come up with some scenario where James Arcelana blew that stop sign and just blasted out in front of James Rode. So they called Andy Klain. I think that the only implication from that line of argument was this was an entirely fabricated defense. And I think that is improper, not only for its inflammatory nature that we already discussed, but for the fact that it impugns what is a legally viable defense in a complicated and unique set of facts in this case. And I would argue, I point to a number of cases in my brief on this point on the right to present a defense point, in which, the SJC, and I think maybe just the SJC, found improper, impugning someone's rights to raise a third-party culprit defense, disparaging or just dismissing a legally viable technical defense as that, referring to the defense efforts to put on a case as a sham, Commonwealth Olszewski, in which the court found objectionable the argument that, quote, if both the law and the facts are against you, you, quote, pick on the cops. Now, I understand and I appreciate that that the prosecutor has the right and the obligation to comment on the evidence as he or she sees fit in a particular case, but I'm just saying that the tone and the words that were used in this case went well beyond that, and that's specifically these that I'm referring to. And if I can turn from the defense itself to the disparagement of the defense expert, our argument is that also went beyond the bounds of fair argument in this case. As noted, the first reference, or it may not be the first reference, but the reference to Andy Klain was in the context of this hypothetical discussion among members of the defense team that they need to come up with something. So let's call Andy Klain. And then Andy Klain, who I will concede was perhaps not the best witness in the context of this case, but that said, the criticism of Andy Klain was not rooted in his credentials, his fee schedule, his expertise, or his training. It was rooted in large part in the fact that he did not have the resources that the Commonwealth's expert had to bring to bear in this context.
I think Mr. Gagne's argument was to contrast how he used to do the same exercise when he worked for the state police and compared it to what he didn't do in this case.
And then true, Your Honor, and then went on to characterize that as this independent contractor working for a defense lawyer for once was playing a different game at this point. And I don't think that's a fair characterization of what he was doing there. What he was contrasting is the fact that he didn't actually weigh the vehicles, which the state police and the state police alone have the resources and the equipment to do. The fact that he did not write a report and present it in advance of trial in the way that discovery requires the prosecutor to do so. I understand that there was
Wasn't it? It was produced during trial too, wasn't it?
It was, and it's unclear from the record when the report was actually, setting aside produced to the government as opposed to produced to the defense. I'm not entirely clear on the.
And Mr. Klain didn't have anyone check his work either, like he used to.
Yeah, apparently he was an independent contractor who doesn't have either the money or the resources to hire.
But my point is that all those things were grounded in the evidence.
And all those things, if they had not led to a characterization of him playing some sort of game, may have been appropriate in this case. But when that goes to, a characterization that this person is essentially a mercenary, that this person is following no rules at this point. We've already established that he's only been called in because the defense has to make up a theory of the case that's going to fit. My argument is that the leading to that comment about he's playing some sort of game in this case, ever since he stopped the good work of working for the prosecutor's office, is an inappropriate argument in the context of this case. The implication is essentially that he was willing to say anything for his client. And they never used the word hired gun, but that was clearly the implication in this case. And both of those lines of argument with respect to experts have been declared beyond bounds in cases cited in my brief. Finally, with respect to the characterization of Sergeant Rode as a cowboy, that wasn't preserved, but I think it just adds to the overall presentation and the prejudice that visited Mr. Rode on account of that presentation. Under Cancel and under other cases cited, this court is certainly at liberty to consider preserved and non-preserved errors to determine whether or not justice was done in a particular case. And my argument is that it would not, standing alone, the characterization of him as a cowboy standing alone would not, I don't think, warrant a new trial, but I think it's something that the court should consider in conjunction with the rest of the arguments. That's part of the closing argument. The last thing I'd like to mention on the argument front is that there's a suggestion in the Commonwealth's brief that this idea that this is a fabricated defense, these comments that suggest that were really just an attack on Andy Klain. That Andy Klain's, late produced materials, his sort of floundering a little bit when asked to do real-time calculations on the stand of other hypothetical situations, that all of that put together, that this idea that they're just coming up with something was a comment on the performance of Andy Klain and not on the defense itself. And I would just suggest that that characterization is belied by the fact that when that came up, when the issue of just coming up with the defense came up, it was succeeded by the statement, so let's call Andy Klain.
Can I ask you a question about prejudice?
Yes.
I take it that whether we're looking at substantial risk or preserved error,
sure.
Your prejudice argument is that the jury would not have or might not have, it would have made a different, how, are we looking at the verdict in order to determine whether there was prejudice in your view, or are you pointing to anything else?
I'm sorry, are we looking at the verdict or are we looking at something else?
Yeah, in other words, I take it that what you're arguing is that the way closing argument was made had an influence on the jury and as a result of that, they found him guilty?
Yes, my argument, I mean, just following the...
We have nothing other than the verdict, is what I guess I'm trying to get at, to show prejudice?
Well, I think the analysis for establishing prejudice in an improper argument cases, there's a number of factors to the court.
Well, there's a number of factors if it's substantial risk. If it's preserved error, it's whether it might have influenced the jury?
Yeah, I think, I think it's a multi-factor test where that's the determination based on, whether or not these sorts of arguments went to the heart of what was before the jury, whether or not they were seasonably objected to, which is the threshold question. And then ultimately, whether or not it could have affected the result of the case. So,
and part of that is how close of a case it was.
Yeah, so certainly in any case, the strength of the Commonwealth's case is a consideration that the court will think about in assessing prejudice. And I'm happy to speak to what I view as the strength of the Commonwealth's case.
I'd like to ask about the jury instructions.
Sure.
Because your brief is confusing in that you begin the argument by telling us that counsel requested and discussed the instruction on negligence, and the Commonwealth says it was just an intervening cause, 5.160, not 524. That was discussed and requested. And then later in your brief, you admit that negligence instruction was not requested and that we're viewing for a substantial risk.
I'm sorry, if it made it seem like he specifically requested that was never, I mean, I may have been.
So we're only reviewing the absence of the negligence instruction for a substantial risk.
Correct. There was no the way that played out and why it's a little bit vague, I think, in the record is because there was a discussion about, well, should we give an instruction about what happens when the decedent has some negligence? And the judge said, yes, that's raised by the case. And then the judge quoted a little section of the intervening and superseding causes instruction. There was no further discussion at that point. And then when they actually gave the instructions, what happened was the intervening and superseding causes instruction was given, but the negligence, the one traditionally addressed negligence, was not given. And
so
what I suspect...
will you agree that there was no other plausible intervening cause except the victim's conduct?
Yes, I will on the facts, which is why I think that giving it at all was confusing while omitting the more appropriate negligence. If there's no other questions, I see my time is up. Thank you very much.
Mr. Gagne.
This is yours.
Good morning, Your Honors. May it please the Court, Stephen Gagney on behalf of the Commonwealth. I was the trial attorney in this case. With respect to my closing argument, I'll address the three issues the defense raises on appeal. First is the blaming the victim characterization of the defense, and I would contend that that is an entirely accurate summation of what the defense was in this case. In a case where causation is one of the elements, as opposed to some other crimes, whether it be a murder or a rape, where causation really isn't the factor. If I were suggesting that there was somehow a disparagement or an unfair attack on a victim in a case where causation wasn't the issue, that may be troublesome. But here, blaming the victim, this was essentially the Commonwealth blaming Mr. Rode and Mr. Rode blaming Mr. Arcelana, and the jury ultimately being called upon to decide whose fault this crash was. I do not think that this was laden in dripping in sympathy or calling for the jury to do anything other than decide this case based upon who was at fault.
The blame the victim comment, excuse me, comes in the following context of what you said, which is a hypothesized dialogue of the defense team to employ that defense. It says, well, they can't challenge the speed. They don't try to challenge the speed at all. Andy Klain admits that the data is, quote, rock solid. He's got to own that speed. So since you can't defeat the speed, how else can we shift the blame here away from Mr. Rode? And that seems to be using you and we to be some kind of imagined internal conversation among someone on the defense side. And then it says, let's blame the victim. Let's blame the individual who lost his life and who's not there. And they tried to say that James Arcelana was coming down Sanderson Street, and you continue. It's in that context, and not in the context of describing relative negligence, that this comment is made. And it seems to me that that context makes a difference.
Yes,
you really don't have any basis, do you, factual basis in the evidence, for imagining what defense counsel's internal thinking was?
Your Honor, I don't think anybody would have thought for 1 second that I somehow was privy to a conversation that the defense may have had.
Exactly, but that doesn't seem to help you.
That it was so obviously rhetorical. I think Your Honor called it hypothesizing. The defense calls it a hypothetical, obvious rhetoric. I think it was so hypothetical that everyone...
What's your best case for saying a prosecutor gets a pass the more obvious the made-up argument is?
Your Honor, I do believe I cite a case in my brief where this court or the Supreme Judicial Court has said that when something is obvious rhetoric, which I don't think any reasonable juror could have found this to be anything but that.
In the context of hypothesizing the development of the defense strategy?
Well,
we've got a case saying that?
Well, Your Honor, speaking of context, I'd like to take that into context because this was a very unusual case where it wasn't as though the defense simply presented an expert to support its theory of the case. This was a case where the trial judge was confronted with a very thorny issue mid-trial, where I moved to exclude Andy Klain because of the egregiously late discovery violations.
Right, but you don't get to address discovery problems, if there was a discovery problem, by getting latitude in your, at least the Commonwealth doesn't. And I don't think anyone does, by then getting to go outside the bounds of permissible advocacy in your closing. And that's, I'm not trying to say you did, I'm just trying to say that can't be the law, that you get to do a different type of closing because the other side did not comply with discovery obligations.
Ordinarily, I'd agree with you. Ordinarily, discovery violations are argued outside the presence of the jury, and the jury doesn't hear about that.
And you don't get to take out your anger about that in your closing or express your frustration about it in closing.
Your Honor, in this case, in lieu of excluding Mr. Klain entirely, the trial judge specifically stated at pages 11 and 12 of the third day of trial that the Commonwealth would be given wide latitude to cross-examine Andy Klain, and unlike in an ordinary case, his discovery lapses and late production, creation and production of materials, of discovery materials, was permissible grounds for cross-examination. Therefore, it was evidence in the case. It was part of the record. And when I'm arguing in closing argument that the defense, quote unquote, came up with a scenario, that's tying back to Andy Klain literally coming up with notes, coming up with diagrams on the eve of trial and during trial. He's literally creating and coming up with this stuff after opening. So when I say they came up with a scenario or came up with a defense, it was not my intention, and I don't think it's a fair reading of my closing to say that I was accusing the defense of fabricating a defense. I specifically tethered it to, so they call Andy Klain, and that's the segue into my critiques, fair and admittedly hard critiques of Andy Klain and his work in this case, which
You don't think we've got to come up with a scenario here where James blew the stop sign and just blasted out in front of James Road? You don't think that fairly suggests fabrication of a defense?
I think that when Andrew Klain is doing the shoddy work he did in this case, literally during trial, I think it's fair to suggest to the jury that they should question whether or not there was some creative...
That's a fair argument. What I'm saying, though, is that you couched it here as the internal thinking of counsel, which appears to me to be something else.
Admittedly, in this case, like some others, I look back and say I should have phrased that more artfully. I admit that. I admit that I should not have hypothesized a hypothetical conversation amongst the defense team.
Right, and then you tie that to the decision to call Andy Klain, and that hypothetical conversation, and there's no basis for that in the evidence.
No, I'm not suggesting there was, and I don't see how anyone could think that I was somehow eavesdropping on the defense.
Counsel, the issue isn't whether the jury would believe that you had this information, that, and that's what we talked about. It's obvious rhetoric, but it's impugning the integrity of your brother counsel.
No, it's impugning the integrity of Andy Klain, and that's why I specifically, the next sentence literally is, so they call Andy Klain, and then I spend the next 5 pages pointing out all the glaring deficiencies of Andy Klain's work in this case, which to call it shoddy would be a compliment. His work was profoundly deficient. And when I talk about not writing a report, not doing peer review, not turning things over in a timely fashion, that has nothing to do with the disparate resources to the Commonwealth versus a defense expert. That's just basic professionalism. And when he's emailing notes and diagrams at 11 o'clock at night during trial, that's not playing by the same rules as when he worked for the Commonwealth. That has nothing to do with resources. So yes, Your Honors, I completely admit in hindsight that it would have been safer to avoid that, what I thought was so obvious rhetoric that nobody for a moment would ever think that that was what actually happened on the defense side. But tethering it to Andy Klain's work in this case, where because this was not your ordinary case, where the discovery lapses were actually rooted in
So when you were saying he is truly doing his job by different rules, he's playing a different game than he used to when he was a sworn law enforcement officer, you're referring to the late discovery of materials?
I'm referring not just to the late discovery of materials. I'm referring, and I put this in my brief, I'm referring to the fact that A, he did not do something as simple as write a report. That's something that was standard practice, and he testified that that was standard practice when he was actually the head of the State Police Collision Analysis and Reconstruction Unit.
And that's a game?
Playing games by different rules, Your Honor, I meant that as just a simile. That's just a comparison. When you're playing by different rules, I think that's something that we all use in everyday parlance.
Different rules, sure. Different games seems to me to be something a little bit different.
Well, Your Honor, there were apparently no rules for Mr. Klain in this case. And I think that saying, I didn't pull any punches with him. And I don't regret hitting hard at his work in this case because it was so deficient. Now, phrasing it as, again, the defense gets together, I admit, could have been phrased differently. But this was rooted in his deficiencies, not the defense. I didn't disparage my brother as saying Attorney Reddington pulled something out of his hat here. It was.
When you say that someone's trying to sell the jury something, how do you distinguish that from calling him a hired gun?
I think it's much different. And again, I think there was an abundance of foundational evidence here to say that he was, doing a calculation on the stand, which basically undermined his testimony, because he was up late doing diagrams the night before that only favored the defense. All of those rooted in his testimony. I think then you can say he's trying to sell something to the jury. I think that was a soft way of not avoiding calling him those words, those titles, those personal attacks. When you're calling somebody something as opposed to what they're trying to do, I thought that was actually within a safer zone than the cases that call somebody a hired gun, a mercenary, willing to say anything for the right price. I didn't go there. So, Your Honors,
Do you want to dress like an 8th grader trying to get a term paper done before finals?
fair.
How
Hard but
so?
fair. I've never encountered this quality of work.
Sure, but you just have to lay out that. You don't need to characterize the witness by calling him names. You did such an effective cross-examination of the expert.
Your Honor, in a case where a young man lost his life and the quality of work being thrown against the wall, yes, I absolutely swung hard. I think they were hard but fair blows. That is the language that this court has endorsed, hard but fair blows. And I think there was a firm and ample evidentiary foundation for my critiques of Mr. Klain. And to think that the jury, getting back to your question earlier about what are we really looking for here, to think that anything that was said in closing, particularly where the trial judge 7 times between her instructions at the outset of the trial and before they deliberated, 7 times reminded the jury squarely of where the burden of proof lie in this case, combined with the 3 times Attorney Reddington reminded the jury of the presumption of innocence and the burden of proof. To think that somehow during deliberations the jury was swayed by me comparing his work to an 8th grader, where in the strongest evidence here, 83 miles an hour in a 30 at night with no siren in a residential area past a hospital. This was an overwhelming case of negligence on Mr. Rhodes' part.
Do you think it would help our review, when you're talking about the strength of the evidence, to have the trial exhibits? Because I didn't see them in the record.
I don't think it would hurt. I think if you saw the diagrams and the damage and the aftermath of the crash here.
It would be very helpful to me, at least, if we could get them, so if someone can submit them to us. And they don't need to be the originals, just true copies.
Yes, I can make sure that all of the exhibits are transferred to this court, Your Honor. Just briefly, I see my time is almost expiring. On the instructions, Your Honor, I believe the instructions were proper as given. They were complete and thorough. They kept the jury's focus on whether or not Mr. Rode himself contributed to this crash, even if there was any wrongdoing on anyone else's part. And most of the instructions were either not requested or not objected to. Your Honor, I thank you for your time. I'll submit the exhibits through the appropriate channels, and I'd ask you to affirm Mr. Rhodes' conviction. Thank you.
Thank you, Bill. We'll take it under advisement. With that, I'd like to thank my panel. I'd like to thank our court officers, our law clerks, our excellent timekeeper, and we will stand in recess.
That's what I was going to ask if they except for one is it Ron Easels?
Maybe.
I'm sure we'll be in touch about
Yeah.